sounds good.
All right, so Mrs. Zell, what case are we calling first? And then I'll give you a chance to talk to Mr. Kemp.
Oh, if you want to, sure. I was gonna talk to you.
Can I do George Arkin, please?
Sure. All right, so we're on the record in docket 25-02-553. That is People of the State of Michigan versus George R. Heem. Appearances for the record, Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Kaplan.
Your Honor, Jeffrey Kaplan, P74943, on behalf of the defendant who's standing to my right.
And sir, you are George R. Heem, is that correct?
Yes.
Thank you. This is the time set for a preliminary examination today. Mrs. Zell, how are we proceeding?
Thank you, Your Honor. At this time, the people and the defense are coming together for a joint request for an adjournment for discovery purposes. The people have gotten an influx of discovery within the past 2 weeks that has to still be handed over to defense for their review. So we would be asking for time to do that.
All right. And is that a fair statement, Mr. Kaplan?
It is, Your Honor.
All right. The timeline has not been waived in this matter. There's a so are both sides requesting a just cause adjournment? That would be that we'd set it as soon as possible, as opposed to if the waiver of the 21-day rule would give us more time to work with. What would be your preference, Mr. Kaplan?
I actually, as always, forget to talk about my client with that because you're not in jail. Mr. Arheem, you are entitled to have your preliminary exam within 21 days of your arraignment in this case. Obviously, it would not be a very productive preliminary exam because we don't have all the discovery. So you could waive that 21 days. That would give us time to get the discovery, review it before we have the exam. Since you're not in jail, I don't see that that's an issue, but that's your decision. Are you willing to waive that 21 days?
I'm cool with that.
Okay.
All right. All right. So with the waiver of the 21-day rule, and I will go ahead. May I speak to Mr. Arheem concerning the waiver of the 21 days?
Absolutely, Your Honor.
All right. Mr. Arheem, you understand you have a right. I'm going to say the same things your counsel just said. You have a right to a prelim within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You were represented today by Attorney Jeffrey Kaplan. He would be present to cross-examine any witnesses, contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to a preliminary examination within the 21-day period. You wouldn't be waiving your right to a prelim in general, just within the 21-day period. And that would be so Mr. Kaplan get all the discovery, review all the discovery, and be ready to zealously represent you in your defense. Is it your wish today to waive your right to a prelim within 21 days?
Yes, only for the 21 days.
And Mrs. L, do you also waive your right to a prelim within 21 days?
We do, Your Honor.
Right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will reset this outside now. We have some time to play with. I know there was an enormous amount of discovery in the matter. So are we looking at 30 days or?
I wouldn't know because I don't know exactly how much there is, obviously. So
there is quite a bit of discovery, Your Honor. I think 30 days would be safe
all right
to give both parties time.
In the vicinity of 30 days.
October 16th at 1:30.
October 16th at 1:30 for the adjourned prelim. All right, so we've set this for October 16th at 1:30. That should give sufficient time for Mr. Kaplan to review any discovery materials and zealously advocate for your defense. Anything else for the record in 25-02-553, Mrs. Zell?
Not for the people.
Mr. Kaplan.
not from the defense, Your Honor.
All right, Mr. Arheem, we'll see you on October 16th at 1:30.
Sounds good.
I'll have a notice for you.
Anytime, George. You can sit out there.
Yeah, how dare
Who do you want to call next, Mrs. Up?
I believe we are ready on William Anderson,
All right.
and then I believe Mr. Russell, William Russell would need to be brought up from the jail, and we are ready for that.
All right, let's go ahead and bring up Russell. Well, Mr. Anderson has 3 files. And did you want to call those together or one at a time?
If you call,
How would you, what would be your preference in calling? Because we've got FTR, NSF, and then weapons charge.
I think if we can call them all at the same time, that would be preferred.
All right. All right, so we're on the record in 2502-332, 2402-920, and 2501-939. That is people of the state of Michigan versus William Anderson. Appearances for the record, Mrs. Up.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee appearing on behalf of William Anderson.
And pursuant to all 3 files, sir, you are William Anderson. Is that correct?
Yes, Your Honor.
Thank you. This is the time set for a preliminary examination in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that an adjournment is going to be sought here. The people do have witnesses and are ready to proceed if need be. However, it's come to my attention that defense would like a little bit more time to go through the evidence on the 02332 case, which is the failure to return rental property, and then the 02920 case, which is the NSF case. We would be asking for a 2-week adjournment on that. The people
Right.
would not be opposed to that adjournment.
And is that a fair statement, Mr. Lee?
Yes, it is.
All right, I have a waiver of the 21-day rule on 2402-920 and 250139. I do not have a waiver on the 21-day rule on the 2502-332, that being the rental property. Does your client intend to waive his right to a prelim within 21 days for the adjournment, Mr. Lee?
Yes, Your Honor.
All right. May I inquire of your client, Mr. Anderson, of the waiver in the 21-day rule?
Yes, Your Honor.
Mr. Anderson, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney John Lee. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination. You wouldn't be waiving your right to a prelim in general, just within that 21-day period, so that Mr. Lee can consider a global offer from the people and more time to look at that. You've done that on the other 2 files. Are you willing to waive your right to preliminary examination within 21 days on 2502-332?
Yes, Your Honor.
And Mrs. L, the people are also waiving the right to preliminary examination. Is that correct?
That is correct, Your Honor.
I find the preliminary examination to be knowing on this case, 2502-332, to be a waiver to be knowing, voluntarily, and accurately made. And we can reset all 3 files for preliminary examination. And how much time are we looking for?
We would be okay with a brief turnaround. 2 weeks would be fine for the people. I would defer to Mr. Lee if you would like any more.
Mr. Lee.
We would prefer 3, Your Honor, but we can do
It-
2
it-
if necessary.
All right, it'll be in that time frame, depending.
We have 2 or 4.
Okay, so let's make it 4 then. Yeah, that we have 2 or 4, and 2 would be
Very well.
if 2 would be a quick turnaround, even for subpoenas. That probably the quickest we could do is 2 weeks. So let's do 4 weeks. So we'll set it for preliminary examination on.
October 10th at 1:30.
So I've set 2502-332 for October 10th at 1:30.
1:30.
Okay, and we'll set for October 10th at 1:30 for 2402-920, and we'll set for October 10th at 1:30 for 2501-939. Anything else for the record in docket, in any one of three of these dockets, Mrs. Ali?
Not for the people. Thank you.
Mr. Lee?
No, thank you, Your Honor.
All right, Mr. Anderson, we'll see you on that October 10th date at 1:30. All right, sir?
Yes, Your Honor.
All right, thank you.
We'll have notice.
And you can get, Mike, when my court officer comes back.
Get money from jail, yeah.
Russell? Liam? William or Bert?
I think, I thought he had some back. Yeah.
Mr. Anderson? We reset Mr. Anderson. And then, Megan, did you bring up William or Bert?
And Mr. Captain's covering Mr. Edwards.
Flores.
That's the one set for exam from Judge Ward.
Why are we going in there?
Same date as your case. This for example, 26.
Why can't we just do it the same day? But for, I mean, I just don't see why we postpone the 25. What are they offering? Around that asking? We're going to discussion.
We could find one.
Or I can get off the bench here for a few minutes to let you speak with Mr.
I can't, Your Honor, though, because there's other people around.
All right, so we just can't, or we can take him back to jail and you can have a discussion with him there.
Okay.
I just didn't know if we could just walk down the hall or sit out down the hall. or
Not
something.
not without the officer present.
Yeah.
Well, and our directives from our bosses, everything's got to be in private. We can't talk in hall.
Okay, so that would make
But you
sense.
gotta go downstairs to talk to them, that's all.
Well, I didn't know that I needed to. I thought you'd already talked to Mr. Etheridge.
We didn't talk about what you were talking about. I'm just trying to make sure everything's all on the same.
All right, so Mr. Russell will be talking to his attorney,
Mr. Kaplan.
Mr. Kaplan.
Mr. Kaplan.
Absolutely. Yeah, just-
I know, I understand, but that's also.
yeah, Gotcha. Thank you.
Ms. Matuzak, are you ready to go on anything?
That's mine.
That's your case? Perfect.
And I told
Gabby,
that
she had a minute, because I thought it was going on the record.
No, she has a minute.
she
She's
ran
fine.
downstairs, okay.
She's fine. Mrs. L, your boss just sold you out.
No, I did not. I was getting ready to just cover it. Make sure.
Do you have anything ready to go? Or you can come get me when you're ready, because I think Mr. Williams has to be taken down, talked to, and then come back up.
Yeah, and I don't have any other defense attorneys.
All right,
now.
just come get me when you're ready.
Thank you.
All right.
All right.
Bill Bay, how are you?
Good, how are you?
Good.
Thank you, you may be seated.
All right. He's got even the CSC, so if I can get that one to run sooner rather than later.
Did you confirm this? You want me to do that tomorrow?
Well, I don't know where she would be, is the thing.
Okay. I got you.
Thanks.
Okay, perfect. Did you get locked? Miss Dimes? Stephanie? I just gotta wait. Oh, you said first. Good. Yep. Okay, so you can have it. Yeah, did I give you an offer? Let's see if I have an offer. Let me also see if I have witnesses here. That'd be a good question. Simmons? Okay, I'll come see you over there. Thank you. I don't know. You okay there? You good? Let me mute.
I don't have any internet. I'm trying to watch it on my phone.
Which case are we calling?
If we could call, I just lost my place. If we could call the Nateria Pierce case.
Materia Pierce. All right, so we're on the record in docket 25-02575. That is people of the state of Michigan versus Nateria Pierce. Niteria Pierce. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee appearing on behalf of Niteria Pierce.
And ma'am, you are Niteria Pierce, is that correct?
Right.
Thank you. This is the time set for preliminary examination today. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that this will be a waiver of offer has been extended to defense through defense counsel. That to preserve upon that waiver, the offer would be to plead guilty to one count of concealed carrying a dangerous weapon, which is count one. Upon successful plea and sentencing to that count, we would be dismissing the remainder. Upon the waiver, this would be open until the first pretrial in circuit court.
And is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
May I inquire if you're a client of the waiver of the preliminary examination?
Yes, sir.
It's Niteria, correct? Ms. Pierce, you understand you have the right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney John Lee. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding it would be your wish today to waive your right to preliminary examination, have this case continue to circuit court. An offer has been made, it's placed on the record, and this offer would be open until the first circuit court pretrial. Is it your wish today to waive your right to a preliminary examination today?
Yes.
The people also waive their right to a preliminary examination.
We do, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. I'll provide the bind over documentation for signatures of the party. I can find it. All right.
My client the one who called the police regarding the incident because this misunderstanding that the electricity was driving drunk with his child. It wasn't one that check. He wanted to make the police to check whether or not his daughter was safe. And again, like I said, the only thought we have is what we could do as the electronic people.
Thank you. So we're back on the record in docket 25-02575. I'm in possession of the bind over documentation. I'll indicate signed by all the parties. I'll indicate the examination was waived on today's date. That's September 12th, 2025. My understanding is the bond is a 10% bond. Anything to come to the court's attention before I sign the bind over documentation on 25-02575, Mrs. L.
Not with people.
Mr. Lee.
Nothing for the defense, Your Honor.
All right, Ms. Pierce, your time in district court is done. You're off to circuit court. Will you get your next date to appear in circuit court from your attorney, Mr. Lee? All right, ma'am? You should be all set. Thank you for your appearance today.
Your Honor, we do have one more request. I'm sorry, I forgot to mention it. Ms. Pierce was put on a tether in regard to bond. And she's been compliant with all probation and pretrial services rules. We don't believe she presents a threat to the society. and has maintained her no contact provisions, we would ask for the tether to be removed.
All right. So I'm going to ask to reopen because I've already signed the binder documentation. Mrs. L, do you have any objection to there? This is a no contact order, GPS, and it's a felonious assault case. Mrs. L.
Your Honor, at this point, we would ask that this just be addressed at the first pretrial and circuit
All right,
court.
this will be addressed at the first pretrial and circuit court. I understand Mr. Lee's position, but we will address it at circuit court. Thank you for your position. What's next, Mrs. L?
I believe they are ready on William Russell.
William Russell. That's Miss Matusak's case.
Yes, Your Honor.
All right, so we're on the record in docket 25-02560. That is People of the State of Michigan versus William Russell. Appearances for the record, Ms. Matusak.
Good morning, Your Honor. Nicole Matusco on behalf of the people.
Mr. Kaplan.
Jeffrey Kaplan, P 74943, on behalf of the defendant who's standing to my right.
And sir, you are William Russell, is that correct?
Correct.
Thank you. This is the time set for preliminary examination today. Ms. Matusco, it's not Ms. Tusak.
It's okay.
Matusco, how are we proceeding today?
Thank you. I had a chance to speak with Mr. Kaplan as well as Mr. Dwayne spoke with Mr. Etheridge. We were treating this similar to a continued PCC. Mr. Russell has additional cases within this court as well as in the 55th District Court. The second case that is in the 54A District Court is related to the incident here in that it's fair to say there has been a lot of incidents going on concerning Mr. Russell. So I believe context is going to be appropriate when reviewing this R&O as well as the fleeing, eluding, and R&O that is currently pending in front of Judge Ward. The case currently pending in front of Judge Ward involves the same two officers, and then I believe it's an additional officer for the fleeing, elude that is not the two officers that would be a part of this case as well. So what the parties want to do and what I talked to Mr. Kaplan about today is I've requested additional information from the Lansing Police Department, additional reports concerning contacts with Mr. Russell that led up to this resisting and obstructing, as well as the fleeing, elude, resisting and obstructing that is pending in front of Judge Ward, because like I said, context is everything in this case. So we are currently getting those reports. As soon as we have them, we'll turn them over to the Public Defender's Office. So I think the parties are requesting that this matter be adjourned and if possible, set on the same date as the preliminary examination. And however, that is in front of Judge Ward.
All right.
So it's not in front of Your Honor.
All right, so two things. First, the request for adjournment, and that would be a request for good cause. Is that correct?
Yes, Your Honor.
All right. Second, I'm willing to take the other file from Judge Ward, depending if you want to set them both. I just don't. That's up to the parties, because these files should be together if we're subpoenaing the same witnesses. So that's out there too. I don't know if Judge Ward would be amenable to that, but I'm amenable to that, and so that can be addressed. Mr. Kaplan, in regards to the adjournment, sounds like there's more discovery.
Yes, Your Honor, and I should say that I am standing in for the attorney of record, Derek Etheridge, who's out today. That is my understanding from Mr. Etheridge. He had requested that we just set this for an exam on the same date as the other case.
All right. So we'll see. Let's see what date's available. When is the other date set for?
The other case is
The
currently
26th.
set for September 26th at 8:30 in the morning.
20, and I'm not here.
So my suggestion, for what it's worth, is we set it for the court, our docket's next availability, which would be on 10/10. And perhaps the prosecutor could speak with Judge Ward's staff, or I can send an email to Judge Ward's staff to see if they're willing to give us both files, and we would just simply put them together on the 10th.
Yeah.
Okay.
That would be the queen. So this is a good cause adjournment.
We will just.
So you don't have to waive any of your rights in this matter. the other request, the only other thing I'm thinking about is that a PR bond was set on this case. Does Mr. Kaplan have a bond request on this case?
That's what he was just reminding
Or else
me
he's
of,
not
Your
collecting any time on this case.
Honor. Correct. It is a PR bond, Your Honor. So what we'd ask is just a nominal cash
All
bond.
right.
So that he's getting credit.
I'm gonna set bond in this matter. So you're incarcerated. You should collect on any time you're incarcerated. I'll set $1,000, 10%. With that understanding, we will hopefully adjourn, was a good cause adjournment to October 10th at,
Let's do 9 o'clock.
at 9 o'clock. And then we'll see if we're able to put the files together. If not, we'll set this afterwards for October 10th at 9 o'clock.
Sounds good. And I'll be in contact with Ms. Matusko about getting the file
All right.
transferred from board as well.
Anything else for the record in 2502560, Ms. Matusko?
No, Your Honor.
Mr. Kaplan?
Nothing from the defense, Your Honor.
All right, you're all set, Mr. Russell. Thank you for your.
Thank you.
Mr. Kaplan, do you know when his 55th birthday is?
Usually do.
Oh. You know what the number is? Oh, you got it.
We're
Okay.
good.
Absolutely.
Where are we heading next, Ms. Azell?
If we could
Ms.
call this,
Matusko, always a pleasure to see you.
thanks. If we could call the Zachary Walker case.
All right, so we're on the record in docket 25-02559. That is People of the State of Michigan versus Zachary Walker. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Austin.
Thank you, Your Honor. Good morning. Jared Austin, appearing on behalf of Mr. Walker. He stands present to my right.
And sir, you are Zachary Walker, is that correct?
Correct.
Thank you. This is the time set for preliminary examination today. Mrs. L, how are we proceeding?
Your Honor, at this time, the people's necessary witnesses have failed to appear. We are unable to move forward without them today. In our case notes, to be honest with the court, we did have a failure with our subpoena system. We tried to contact the complaining witness to get another way of sending that subpoena to them. And they actually rejected us sending them a subpoena or giving us a way to do so. They did tell us they were going to be here today, but clearly they are not. We do expect a motion from the defense at this time.
Mr. Austin.
Thank you, Your Honor. Given that, for whatever reason, it sounds like the necessary witness is not going to be participating. It doesn't sound like they were to be given another opportunity, we'd have a different result. So given that, Your Honor, I would ask the court for dismissal at this time. Understanding, of course, as a matter of law, the dismissal is without prejudice.
All right, thank you. So the people are unable to proceed today. There was some contact with the complaining victim, but they were subpoenaed, but there was contact with them and they have not appeared today. I'm going to grant the motion to dismiss without prejudice. So we'll get that printed out. So, Mr. Austin, I'm going to draft you to grab the dismissal. Is there one on the printer?
There should be, that should be.
Oh, I was looking up there.
This is not in your job description, Mr. So if you hand me that, I can.
Also a notice to appear for somebody.
All right, Mr. Walker, if you hand me is that the dismissal? I'll sign that. Thank you, Mr. Austin. All right, so I'm in possession of the request for dismissal made by your counsel on 2502-559. Usually, this is, the default is dismissal without prejudice. This may be reissued, okay? We're not certain. The prosecutor's office will contact the complaining victim, and this could be reissued, which starts the whole process again. It may not be reissued, so that's completely unknown at this time. But I'm going to grant the dismissal without prejudice, and that's what without prejudice means. The people could reissue if they choose to, but they haven't talked to the complaining victim, and it appears that any contact's been somewhat unsuccessful today.
Okay, makes sense.
All right, so I'm going to sign the dismissal without prejudice. There is a no contact order on the file. So we'll make a copy of this, and you should keep it on your person because it takes about 4.5 hours to purge from the system.
Okay,
And so you'll have this as a dismissal.
okay.
Anything else for the record in 2502-559, Mrs. L?
Not for the people, thank you.
Mr. Austin.
I have nothing additional to that, Mr. Walker.
All right, we'll provide you a copy of this. You can keep on your person. Thank you for your appearance today.
You're welcome.
What case are you ready for, Mrs. L? Or do you need a break in the action?
We're gonna be ready to go on Higgins. If I could just have like 5 minutes to get prepped for that, we are gonna run that exam. It should be a one witness
That's
prelim.
Jawan Higgins.
Yes, and there will be no physical evidence admitted. today.
All right. at 25-02-553. That is People of the State of Michigan versus Jawan Higgins. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Austin.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Higgins. He's present with me at council table.
And sir, you are Jawan Higgins, is that correct?
Yes.
Thank you. This is the time set for a preliminary examination today. Mrs. L, how we proceed?
Your Honor, it's my understanding that today we will be running this preliminary exam. The people plan to call one witness to the stand today, and that would be, I apologize, I had her name up earlier, Demaria Beard, thank you. And we do not have any physical evidence to present for today's preliminary exam. I'll defer to Mr. Austin for any additional.
All right, and so that's your understanding, Mr. Austin, and there's a request to have the witness appear through judge's chambers in order to proceed to the witness chair. Is that a fair statement, Mrs. Up?
It is, Your Honor.
All right, Mr. Austin, any objection to the witness going to judge's chambers to appear, and then anything else, any preliminary matters to come to the court's attention?
Yes, Your Honor, it's my understanding we're conducting the preliminary exam as well. I do not have any objection for the purpose of this hearing to having the witness come through chambers in order to access the witness stand. It's where a jury trial would be a little different, but I don't think there's the danger of the prejudicial impact for this type of hearing that there would be in a jury trial. So I would not object to that for the purpose of this hearing. Just beyond the ordinary order for sequestration, I would not have any additional issues to come before the court.
All right, so I'll invoke the sequestration order. So if there's any, and counsel knows the case better than I do, if there's anybody presently in the courtroom who should not see another witness testify, bring it to the court's attention, and then I'll make sure to invoke and then to enforce the sequestration order. The detective, the investigating officer can be present at the table. And Ms. Thompson is an intern with the prosecutor's office. Mr. Billabay is with the prosecutor's office. I believe Mr. Silverthorne is with the public defender's office. So I don't know the other witnesses, but if you don't see anybody, I'm good. All right.
As far as I'm aware, the remainder of the people in the gallery, Your Honor, are not connected with the case to the best of my knowledge.
Just let me know and I'll enforce the sequestration order. Anything else to come to the court's attention before we get started today, Mrs. L?
Not for the people.
Mr. Austin.
No, Your Honor, thank you.
All right. So Mrs. L, you may call your first witness, and Ms. Slaviak will meet Ms. Thompson, and we'll bring her in through the judge's chambers.
Thank you, Your Honor. At this time, the people call Demaria Beard to the stand. Demaria Beard.
All right, Ms. Beard, I'm going to have you raise your right hand. Please state and spell your first name and last name for the record.
DAMAURIA
All right, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, you can have a seat, ma'am. Please project to the back. The microphone is for recording purposes only. It goes right to the recorder's ears. So please project as best you can. And Mrs. L, when you're ready.
Thank you. Your Honor, before I begin, it's come to my attention that there's been a request for somebody to sit next to Ms. Beard during her testimony. The request was for the detective to be that person. However, I feel like defense may have an objection to that. If defense would be willing, would Ms. Thompson be able to sit as a support person for the witness today?
Any objection to Ms. Thompson? What we do is we just move her over.
Correct.
Yeah.
Yes.
So she's sitting, so we'd move her over like 2 seats over, move the seat over. That would be the extent of the support person. Any objection to that, Mr. Austin? And I know this is probably brand new for today.
And it is, that was not brought to my attention until just now. I would say it's a bit unusual. It's not something that there's a provision for in the law like there is with, minor witnesses. So I guess I would just state that. I mean, if the court is going to grant the ability for the witness to have a support person, just so this is probably more primary for the witness's benefit than it would be for the support person, is that the support person is just to kind of remain there and keep them company. They're not to coach or talk to them or anything of that nature.
All right, Mrs. L, response.
Thank you, Your Honor. This actually is a pretty typical practice that we do in our office for cases such as this and for domestic violence cases. Typically, we do have someone called a victim advocate sitting next to them. However, our office is a little short-staffed of victim advocates at the moment. Oh, we actually have one here too, so we could have that person come up instead if defense is more comfortable. However, saying this is not normal practice would not be a correct.
So first of all, who would be the person who would be the victim witness person? So what I would do is I would move you to the chair right next to Mrs. Thompson. And in essence, we have the victim witness person, Ms. Thompson, who's an intern, and the detective within 6 to 8 feet. I think that should suffice today.
I think it would, Your Honor.
We're asking for rearrangement of the courtroom, but we're really not doing a lot of rearranging. Mr. Austin.
I'll stand on my original record that I created, Your Honor.
Thank you. All right. I'll allow the victim witness person can sit in the chair. Yeah. And should have no contact with the witness during testimony. And then I'm sure Mr. Austin could cross on that. But you can sit right next. All right. With that understanding, I believe we rearranged the courtroom barely. And Mrs. L. So Mr. Austin, any further record you wanted to make in this regard?
No, Your Honor, I'll stand on the original record that I've created as far as that issue. Thank you.
Thank you, Mr. Austin. All right, Mrs. L, you may proceed with your questioning of the witness.
Thank you. Thank you for being here today, Demaria. Can I just start by asking, where do you currently live?
3200 South Washington Avenue, Lansing, Michigan, 48910, apartment 137.
Thank you. And do you know if that's in Ingham County?
Yes,
And how long have you been living there?
I've lived there since March 21st, 2024.
And is that an apartment building?
Yes,
Is your unit inside or outside of the building?
it is inside the building.
Do you happen to know like approximately how big that building is?
187 units.
So quite a few people live there.
Yes,
I want to take you back to November of 2024. Do you remember November 17th?
yes.
Okay. And do you remember anything happening on that day?
I remember that a fire alarm was off.
Do you remember what time that happened?
I think it was around approximately 5 o'clock in the morning.
Okay. And when you heard that fire alarm go off, how did you respond?
Panicked.
Okay. Now, in that panic, did you exit the building?
Yes,
Where'd you go?
front of the building.
Okay, like the front lawn or out into the street?
I went through the front door.
Okay, so front door. Did you move away from the building?
Yes,
Were you the only person exiting the building?
no,
Okay. Did you go talk to anyone?
yes.
Who'd you talk to?
I talked to the person that is also in the courtroom today.
Okay, and do you happen to know that person's name?
Yes,
Would you mind telling me that name?
Joanne Higgins.
Okay, now is this the only person that you talked to?
No,
Okay, so help me get a picture of what happened when you exited the building. Was there a group of people?
yes,
And did you approach that group?
yes.
What happened when you approached that group?
We were discussing why there had been a bunch of recent fire alarms that had been pulled.
Thank you. I'm going to take a brief moment for a second. And I know this is uncommon, Your Honor, if I could make a motion to have us taken off of YouTube for the live stream for the remainder of this.
Any objection to being off of YouTube from the defense, Ms. Ross? Because I am live streaming this.
Sure, I would leave it at the discretion of the court. I don't think there's anything that mandates one way or the other, whether the court needs to or doesn't need to. The courtroom is open to the public, so that I think alone satisfies the public courtroom requirement as it relates to the YouTube issue. I would leave it at Your Honor's discretion.
All right, and I believe that is the nature of it. The courtroom has not been closed, but we lose track of the person who's coming on YouTube. So if they did want to watch the preliminary exam